Hi, my name is Adam. Welcome to another episode of Step by Step Financial Solutions Academy. Today we've got a really special guest, someone who is extremely qualified to talk about all these aspects of buying and selling a property. I would like to introduce you today to someone who I personally trusted with my own personal legal affairs and someone who I've known for many, many years. So, Ken Flooks from Ackroyd Legal. Welcome to Step by Step Financial Solutions Academy, Ken.
Thank you, Adam.
Ken, thank you very much for taking the time again. This is a really special episode for us because a lot of people requested to talk about the legal aspect of buying and selling the property. So what we're going to do today is we're going to cover all the questions. We're going to debunk hopefully some myths because there are a lot of misconceptions about buying and selling the properties. So why don't we start with some information about yourself? Could you tell us a bit about your background?
Yeah, I left grammar school when I was 16. I joined a firm of solicitors in Southampton who are still going, believe it or not. Worked my way through nearly every aspect of law, maritime law, ecclesiastical law, right the way through to crime, matrimonial, and then decided I preferred conveyancing, and then started moving around to some other firms, doing specialty work, and then eventually arrived back here home.
In Southampton?
So, yeah.
That's brilliant.
And now just entering my 60th year in the legal profession.
So you've been doing this for nearly 60 years, am I right?
Yeah.
Wow. We're really glad we can pick your brain on the subject of buying and selling property. There's a lot of questions.
There are some cells left in it. Yeah.
Amazing. Let's start with some practical advice for our viewers, and let's start with things like a boundary dispute or the boundary itself. When you buy a property, a lot of people envision their garden being perfect, and very often one side of the fence isn't quite as right as the other. Which side of the fence belongs to the property? Because there are certain misconceptions, so if you could maybe clarify that.
Some people think the right, people say the left. Some say none of them.
Is there any rule?
The only rule there is if it's stipulated in documentation.
Okay.
A lot of new properties or new developments are party owned, shared with adjoining owners. Very older, the much older properties, very old misconception was the left hand, believe it or not.
Okay.
You thought it was the right hand.
That's right, yeah.
Who does own it? If you're in the middle of a terrace or something, you don't own both of them. So when the wind blows them over and your neighbours say otherwise, they're not your fences necessarily. They always are when they blow over, by the way. If the post is your side and the panels are on the other side, that is your fence.
Okay.
If it's a brick wall and the buttress is your side, that is your wall. If it's the other side, it's next door's. If the posts go down the centre line of a boundary, they're normally party or jointly owned fences.
Right. So can that information be found somewhere?
Yes. Yeah. You have to rely upon what you're told and from an inspection of those fences. Grey areas sometimes, particularly where people haven't maintained them. And people do fall out over boundaries more than anything else, by the way. Boundary disputes are probably the most common of all disputes. If the boundary isn't maintained and your neighbours do own it, you can always erect your side of the boundary.
So effectively, even if this is not my boundary and the fence is in mine,
yeah.
but I would like the fence to match all over the same.
Yeah, good neighbourly thing, of course, is to go to your neighbour and say, look, appreciate you probably can't afford to do it or don't want to do it. We're going to put our own up. Do you object? And normally they say no, because it's not going to cost me anything.
That's right. Yeah, it can be pricey, but effectively we can always go and approach the neighbour and talk to them about it. That's brilliant. So another question could relate to kind of a post-completion situation. Many times people are shown the property in their best state, where the furnitures are there, and you're going around and you don't really see every aspect of the property. What happens when at the point of completion you're collecting your keys, you're going around your new home, and you're finding out that it's very different than from what you remembered?
Yeah, we've had a situation where someone had a big settee, and when they moved, the settee was removed and there was no carpet under it.
Okay.
They'd cut round the carpet, round the settee. You can only buy what you see, really. People do have misconceptions on what you consider to be tidy and clean and what's going to be left than what the people you're buying from do. And you have to trust them.
So would you say maybe going before the completion, just the last viewing?
If someone says, what's going to happen, say, go around and have a look. And if the estate agents or the seller says no, there may be a problem.
There may be a problem. This is actually an indication, yes, we really want to go.
The alarm bells ring, don't they? If there are major problems which have been withheld, not disclosed, you have got redress under terms of the contract, but there's very little you can do about it. But apart from going to a small claims court.
Right, but then you're going through the legal procedures, and it may not be worth it.
And sometimes it's worth biting the bullet and saying, well, we'll do it ourselves.
So the best thing probably for someone is to have a last viewing before the completion, before the exchange of contracts.
A prudent person would.
Fine.
Whether you can or not is another thing.
But if you phone up the estate agents and you insist on it, they should show you. Because many of our clients will ask as well whether they can see the property second or third time. I know that for the estate agents it may not be a trip which they want to make to the same property again. However, for the buyer, it's a slightly different scenario, isn't it? Is their investment.
It is their investment.
So they can make as many visits as they wish.
The ones they can get away with.
Indeed.
Yeah.
Talking about a subject of estate agency, obviously they play a very important role in the property selling and property buying process. Very often the buyer may ask a lot of questions about a property and the estate agents will respond. They not always have all the information, but should we rely heavily on what we were told by the estate agents, or are there any other sources where we can clarify all this information?
Estate agents have got a difficult situation. They can only rely on what they're told, but they do. Some do tend to guess what they think is right, whether it's freehold, whether it's leasehold. If they've got up-to-date measurements and things, that's fine. But you have to rely on the fact that they are not lawyers. They're only trying to sell a house.
So they may have been told the wrong information by the vendor, for instance?
By the vendor, or the seller, we call them now. But they can only rely upon that. So
normally the things like the length of the lease, or the service charges, or the ground rent.
The ground rent is £10. No, it's not. It's 1,000.
Yeah, you don't want to find out after completion. So would you say that after the solicitor clarifies all the information, is that when you can be actually certain about?
We would know from basically day 1 or 2 if that information was accurate or not. We have someone here that really goes through it like a fine-tooth comb, and we'll say, wow, there's a problem here. The agents say there's £150 a year for service charges and £10 for ground rent, and it's like 10 times more. So someone has guessed that or been told the wrong information.
Right, and sometimes even the vendor may mislead the agent.
They do
then
that.
They pass on
to
the
sell
information.
The property. Yeah.
Fine, I see. Okay.
But we know all those things from the moment we get the contract pack.
Fine. So ask the estate agents, get the initial information, but then get it clarified by your estate agents. So it's probably worth as well for someone to make a note and then maybe send them to the solicitor at the very early stage. So then no one wastes the time, because effectively if the solicitor have got those questions early, they can clarify those information, and if there are any misconception, you always got a time to go away from the transaction.
You have situations with loft conversions.
Okay.
when it is actually not a habitable room, but is sold as another bedroom, which is wrong.
So in that situation, that can
wrong.
be a really problematic.
We've had
thing.
several of those recently, where the agent said it's a loft room, yet the actual photographs and layout, it clearly shows it's a bedroom.
Okay.
So that you say, wow, what's going on?
So would that mean that the buyer can have a problem in terms of what the problem with the local authority, for instance, or
Local authority, freeholders if it's a leasehold place. But say we've had several, and they've been very difficult. The groundwork on that and investigation is very, very crucial. Because if a property is advertised as, say, a 4-bedroom house, when it's actually a 3-bedroom house with a loft space converted into a room, planning permission, building regulations, fire regulations, that's another big aspect of it.
So would you normally classify that as a bedroom, or would you just say is
Loft room.
Loft room.
Storage.
Very often it is actually a storage.
Storage, yeah.
So Ken, why don't we talk about some very important stages of the transaction, and one of them is the exchange stage. What does it actually mean to exchange the contracts, and are there any legal implications with exchanging the contract?
Quick rewind. Package comes in, searches are done, inquiries are made, completed. You then are at the point, subject to a mortgage, of course, which is down to. That's the time you need to go through everything with your clients. The exchange commits each party to proceeding to completion.
So after exchange, there is really tough to...
It's full commitment.
So you've bought a property.
Effectively.
Neither party can
effectively. I think the process in Poland is slightly different.
Very different, yeah.
And believe it or not, it's very different in Scotland.
Okay.
But in England and Wales, of course, it's typically English and Wales. Once you've got to exchange and you've exchanged, the rules are very clear. Unless it's a new build or it's a flat, buildings insurance must be put into place from that day, not completion, from exchange of contracts.
Because you are liable.
Because as a buyer, which I think is incorrect actually, but that's only my opinion, which everyone's entitled to, you are responsible once you've exchanged, because you have this commitment to complete the purchase, no matter what happens to the property.
So that's why lender would expect you to start your building insurance at that point, because if anything happens with that property, you are obliged to proceed to the completion stage. Is that right?
Some years ago, Nationwide, for instance, would insure it whether you asked them to or not.
Okay.
Just to cover themselves. Whether they still do, I do not know. But we make it very clear from day one, on exchange, insure the property.
Have you ever, in your experience and your career, had a situation where someone actually exchanged the contract and they couldn't complete?
Didn't.
Yeah.
Yes, several.
Okay.
That doesn't happen very often, because the amount of money they could lose, especially the deposits, and the compensation and other claims under the terms of the contract, doesn't happen very often. But we've had someone.
So what are the consequences?
Consequences, penalty interest under the terms of the contract. Bearing in mind it's linked to the normal bank rates, which is not very high at the moment, as you all know.
It may change.
But in the days when it was 8% or 12%, plus 4%, which is what you could make money out of defaulting on a contract.
Okay.
You know, thank you very much, I'll have some of that. So apart from penalty interest, you are then responsible for the losses of your sellers.
And if you are within the...
And if you're in a chain, their sellers and their sellers.
So if there's a long chain,
you could be in desperate trouble.
Right.
Under the terms of the contract, it's normally 10 working days. If you haven't completed, they can rescind the contract. You will forfeit your deposit, and then be open to be sued for the rest of the purchase price and any other losses.
Okay, so it's very important to make sure that you actually are ready to complete. So you've got your funds ready, you send everything to your solicitor. Fine.
The problem today is everyone wants everything done yesterday. Years ago, it used to be exchange a contract and you had to wait 4 weeks.
Okay.
Because things weren't as simplified. They didn't have proper computers then. We had typewriters and things. And 28 days was a requirement.
Should people then rely on the Help to Buy ISA accounts when the part of the funds, the bonus from the government is coming from them and they form a part of the deposit? Can that be something which the buyers can heavily rely on, or should they actually treat that as an additional funds?
Help to Buy ISAs are additional funds from the government. A lot of buyers think that it should go towards the purchase price, or the balance of the purchase price. Well, it doesn't.
Okay.
Because if once we've exchanged and there's a Help to ISA, we have to apply for it. If you complete and you haven't applied for it, you lose it.
Okay.
Which then puts the solicitors in a very difficult and embarrassing situation. A lot of clients think, well, can you deduct the money when you get it, because we receive it from the government.
Mm-hmm.
Can you deduct it from the balance we owe? And the answer is no. We get it, and immediately we complete, we then send it on to the client.
But you request the funds, is that right?
We have to request the funds. The reason for not paying it or taking it as part of the purchase price is because the government could change its rules on Help to Buy. They could cancel it and say, sorry, no one's going to have this anymore. Boris might say, you're not having it.
And as you know, they can change the rules anytime they want.
Yeah.
Fine.
So you get it, and we part with it. Well, this firm as a whole, we part with it straight away. So the client would get it straight back.
Well, you can't control when the money arrives to your account.
It will always be here on or before, but we can't use it.
So I'm going to ask you now about the conveyancing process. When does it start? Okay. So let's talk a bit about the conveyancing process in general. When does your work actually start?
When we are notified that someone wants us to act for them, whether it be through a broker, estate agent, direct from the clients, we would want in, if there's an agent, sale particulars, property information forms, things like this. But we don't actually start the process until we've sent out a bundle of documentation to a prospective client. They have to fill that in and return it to us. We don't start anything until that's back with us.
So you would normally be contacted by the client, we would like you to act on our behalf, and then you would receive what, the memorandum of the sale, is that right?
That's right. The package...
But your work doesn't start as yet, so...
In the background it does, but we will not do a full-on activation of that until we have completed forms from clients.
Fine, so you have to have all the forms from the clients, all the
ID,
instructions, ID...
Mortgage sources, money sources.
Okay, so when can you actually start working on the case itself?
When we've got the contract pack.
So
the contract pack hopefully would have arrived. The stuff from the client would have arrived. Maybe they would have remembered to send us the search fees which we asked for, and then we start work.
Fine, because I know that in many occasions the timescales can vary from the transaction to transaction, and I think the people have to understand that there's limited things which solicitors can do before you receive the contract pack, and that's really from the
actual
vendors.
Process. It's very set, but a lot of solicitors firms don't stick to that. They will go way into a transaction and not actually be ready because they haven't completed funding sources, they haven't completed ID checks. We've had a load of those recently. We don't move without any of that.
So you have to have a
because we can't
strong
really.
foundation.
Yeah, exactly. And it's very simple to do. We have to rely upon agents getting memorandum of sale and things like this to us quickly. Sometimes they're a little bit slow, whether for one reason or another. I'm not going to criticise that, but they could take time. Clients could take time. Well, we're off on holiday, we're skiing. And that takes another few weeks. So, 4 weeks or 6 weeks could be taken out of our timescale through lack of documentation. We have to rely upon mortgage offers which is down to another group of people called brokers, or clients going direct to mortgage lenders. And that's the bulk of the work is then just before exchange of contracts.
So how long would the normal transaction take? What are the...
Well, some people might disagree with it. 6 to 8 weeks for a normal transaction.
And that's after the contract lands on your desks?
Yeah,
right.
And if it's leasehold or something like that, it could take 8 to 12 weeks.
So the leasehold, so when you're buying a flat, the transaction is likely to take longer?
Yes.
And why is that?
Because of the documentation required on a leasehold flat is massive.
So then because another party is involved in the transaction?
Third parties and sometimes fourth parties.
Okay.
Freeholders, managing agents. The managing agents for the freehold is one thing. If there's a management company, they're agents. And we have to get from them leasehold information packs from both or more.
That's after getting this information, that's when you can clarify to the buyer, listen, we have seen the papers now and the lease is, let's say, 100 and 125 years. That's when you're certain about the term.
And seller solicitors who have got to apply for these packs have to pay a substantial fee in most cases, which they need to get from their clients. If their clients don't pay, we can't get these leasehold packs, which will delay it even more.
So would the solicitor be likely to charge more for the leasehold transaction, or?
Very much so. Probably 25% more.
And that's because of the bulk of work which is involved?
Yeah. Yes, it's about 25% more. In fact, on a lot of cases, it should be a lot more than that, but it would make legal fees look silly.
So what's normally involved in the contract pack? So you received a bunch of the documents, someone is seeing the property once and they rely on your checks. What are you actually checking within the
first thing we
contract
check, is it registered title? Up-to-date office copy entries if it is.
So you don't want to buy the property which is which doesn't belong to the person who is selling.
Exactly
is that right?
You got it. And we see that again as well.
Okay.
There's 2 people on here, but we're only buying from one. Where's that other person gone? Departed, or divorced, or whatever.
Or they've inherited the property and
they've just gone.
Okay.
Death's a normal thing.
So you have to clarify the person who's selling is the owner.
The quickest way is if it's registered title, it's land registry, you can get it within minutes if you've got access to the land registry portal. We do.
Is it common that the property is not registered?
Locally, yes. We have quite a few unregistered properties. Pre-1975, it was not a legal requirement in this area to have registered title.
That's in Hampshire?
Yeah, and other places. London have been registered since 1925. And that's where all of them were. But out in the sticks, like down here in Hampshire, 1975, Eastleigh was compulsory. Here was compulsory, Southampton. But people who didn't sell, didn't do anything much, their titles wouldn't need to be registered. So we say buy a property now, which is unregistered, bundle of old deeds. Interesting.
And you have to register that property. That's
compulsory registration. And unless you have done unregistered property law, you would struggle. And a lot of firms do, because they're the new generation of lawyers haven't got a clue about unregistered land, because it wasn't their era. I was brought up on it, thank God, and I can remember what happened.
So another things which could be included in the
contract. So contract title documents, registered or unregistered. It should have property information forms.
Okay.
Supplemental information forms about.
So the property information form, what sort of information would be included in that document?
Boundary ownership, disputes, insurance claims, electrical, gas certificates.
Things like alterations
to the property, planning, building regs, parking, all things like this. Anything unusual, disputes that you're going to leave the property.
Insurance claims, that sort of...
Everything is in there. It's quite a lengthy document, good one if it's answered correctly and honestly.
Okay.
They're probably adult occupiers other than the sellers, because that's important. Then you have fixtures and fittings list.
Fixtures, because this is an interesting one as well, isn't it? Because
It's a very interesting one, Adam.
It's really important, because a lot of times the buyers will have a conversation with the owner and they may agree on something which is going to be left at the property. And sometimes it doesn't happen, right? So you may say, oh yes, we will leave this fridge freezer and this cooker will stay as well, and this microwave and this sofa, we don't need it. And you may even have an agreement with the buyer and the seller that you're going to actually pay them a certain amount of money. What's the best and safest way to go through these arrangements?
Through solicitors.
Through solicitors.
Without a doubt. Don't pay anything direct to anybody. Because if you say, I'm going to buy this, I'll give you the money on completion, and you go around there,
and it's not there.
It's not there.
So effectively,
or pay in
solicitor,
advance, and it's not there.
So solicitor can actually protect both parties.
Yeah, the
right?
contract has a provision about chattels or content, and you can form it part purchase price, then the additional bits.
So there's no harm when you've got a agreement with the buyer and the seller to phone up your solicitor and say, look, we've agreed that, and the solicitor can put it in the contract, and then at least.
Then if they disappear, having paid for it on completion, that's when you have to step away and go through a small claims court.
But then at least you've got to prove that this was within the contract.
If you can move in first thing and the money's still around, you might better say to the seller solicitor, have you still got that money? Because they've gone off with all this stuff. And a lot of them say, no, we've already paid it out, sorry. But they still could have it.
And who pays the estate agency fees? Because that's often
the sellers.
As well a question. So the sellers,
yeah.
Is that as well via solicitors, or would you say that they pay directly?
Most estate agents rely on solicitors to discharge it for them on completion. But we have to have authority from the client to pay it if we're selling. And if you get estate agents falling out with clients, they're acting for the sale, who say you're not to pay them, we mustn't pay them. Because that's down to we act for the client, not the estate agent.
Okay. So the things like gas safety certificates or electrical certificates, are they likely to form part of the contract? And is it actually a legal obligation to have those documents from the sellers?
We always raise questions about lack of certificates for gas inspection.
So it's a good practice, but not a legal requirement?
Very good. Yeah, it is. You know, it's a legal requirement on letted, properties.
So it's different for the buy-to-let properties?
It's a compulsory thing. And I think it should be made compulsory on any transaction. Because the same problems arise, like carbon monoxide poisoning and faulty electrical things, but not on a private sale.
So it's a matter of safety, it's nice to have it. But
we say the information form should tell you when it was, the central heating system was installed, when it was last serviced, and here are copies of the service agreements and service inspection certificates, electrical certificates. We've had it all checked. Again, a prudent buyer would have that done if the seller hadn't done it.
So if I'm buying a house and I really love it, but there are no documentation in relation to the electric, can I actually instruct my own?
Yes, do go via the agents, consent from the seller, we need an electrical test. And if they say no, then there's something wrong.
Okay.
Invariably there's something wrong.
Because they may say no to them doing it, so they don't want to actually pay for it. But if I'm a buyer and I insist, look, I would pay for that so I can do that, they will just grant an access.
And you do that before exchange of contracts. So if you have an electrician goes in there and said, don't touch it, it needs a rewire, you say to the sellers, this is probably why you didn't want to give it to us. We want either a price reduction or we don't proceed.
Because that may be a really expensive mistake.
Very expensive. Rewiring and boilers. Probably the biggest complaints we get for services.
Because the boiler is an interesting one, isn't it? Because it
old,
may work one day and it may not the other.
Break down the next day. Yeah, that's just the way it goes. That's chance you take.
So the only thing which you can do is actually have a service book if the boiler was serviced every year and you've got all the certifications and the building regulations and all the rest of it. You can at least cover yourself to a certain extent, but you can't really predict how long that boiler gonna be working.
The new generation of boilers have really got a very short lifespan, 10 years if you're lucky, whereas the older style, the dinosaur boilers, could last 20 or 30 years, but they're not as economic
as the new one.
Yeah.
Yeah.
And friendly, eco-friendly, but they do last.
But you would get like things like a guarantees on it. So if there is
new boilers, normally a 5-year guarantee.
Yeah. Yeah.
And sorry,
it depends.
They do. Yeah, it depends. And if you don't service it every year, that's null and void.
That's okay.
And that's another thing we check. We've had again recently. The bad time of year is autumn, winter, early spring. Everything goes wrong with boilers. And whether, as you say, it worked yesterday, but it's not working today, can't help it. It's just one of those things.
So after completion, we need to collect the keys. So at the point of completion, we will be contacted by normally estate agents. Is that right?
And us. We
solicitor.
notify clients. Off you go. Collect your keys. Keep off the phone. Stop telephoning us, please. You have got the keys being released.
We hope you're happy.
Happy moving. No extra charge for the sunny weather.
Yeah.
Estate agents should also phone them and say your keys are here to be collected.
So what happens with those new type of online estate agents? What sort of arrangements do you see around that?
The ones we've dealt with in the past is someone, the vendor or seller would be there to hand them over, or they get someone local to go there.
The local agent may meet them at the property.
This is a slight downfall of it, but if it's organised properly, it's easy, just the same.
Fine, excellent. So another really common misconception is buying a flat which may be advertised as a freehold flat. Can you please explain what does it mean really to buy a flat, and are there really the leasehold flats?
If you're going to buy a flat, it's going to be leasehold. If it's not, you don't buy it.
Simple as that.
Simple as that.
Because I know there are obviously problems with financing those things, but there are probably other obstacles legally.
You can't get mortgages on them.
So how to ask an estate agent if you clearly see that this is a flat and it's advertised as freehold? A lot of buyers love freehold, they stay away from leasehold, and this is something again we would be nice to talk about today. But what sort of questions would you ask a estate agents to clarify that information?
Have you got your facts right? It should be leasehold. It could be leasehold with part ownership of the freehold. So if you have a house which has been converted, 2 flats, the owners of both flats own the freehold jointly.
So you get like a share of the freehold.
Share of the freehold. We have loads of those in Southampton and around
So why
here.
this leasehold is so important? Is the
enforceability of the covenants against the other owners.
So the covenants, by covenants you mean the rights and obligations of the owners?
Insurance, shared services, community service, communal services. It has to be regulated and strictly adhered to. Otherwise, it would just be bedlam.
Because otherwise, if something goes wrong, you got no document to actually follow on.
Yeah, leases. If you have a block of flats and you have tenants, which is another name for, by the way, under leasehold property as a lessee or an owner, and 3 or 4 of them are permanently raving or whatever, you should be able to enforce the covenants of the lease.
So for your protection as well.
For your own protection and for the protection of others. And freeholders will enforce it. And you should be able to enforce it if you're a fellow lessee. And leases have to have that enforceability clause in them to make the freeholder enforce those covenants. Otherwise, it's defective. It's called a defective lease.
Right. So this will apply to things like putting your own satellite dish or having a patch in the properties. That sort of things as
there
well?
are some which are trivial, but there are some that must be adhered to. Paying your way. If you've got a block of 4, 3 are paying all their service charges and everything else, and the 4th one isn't, that could prevent the management company or the owners from carrying out essential repairs. It's those things that need to be monitored and enforced. Leasehold properties, particularly flats, is a whole different ball game.
So
we could spend hours talking about that.
So there is no particular reason to be scared of the freehold property?
No.
So people who buy
not a freehold flat though.
Okay. So people who buy a freehold property, I'm not sure again if everyone is aware of the restrictive covenants which could apply to owning a freehold house. So when you own a freehold house, are there any restrictions, or could there be any restrictions in place as well?
Properties built in probably 50s, 60s, 70s probably had very few covenants on them. Probably only about fencing and using it as a private dwelling house and not doing anything naughty there which could offend other people.
So again, the covenants, by covenants you mean, again, the rules and regulations around owning that property?
A lot of people describe covenants as promises that you will do this and you will do that.
Okay, that's interesting.
Basically, that's exactly the same as what you were saying. It's rules and regs. The latest generation of freehold properties, if they're on an estate, are very similar to leasehold properties and expensive as far as the requirements of common areas, management of, estate charges, rent charges.
So do you actually mean about like new build estates?
New build estates are invariably a headache, and they're getting in the league of leasehold properties.
So you have to be really careful when you're buying a new build property.
New builds are expensive now because you have to give notices, you have to give deeds of covenant and things like this to observe and perform covenants in the same way as a leasehold flat. And it's an open book for these managing agents to charge it. You know, £500 or £600 for a freehold property. Wow.
What about an indemnity policies? I know that this is something which can be very...
You can indemnify against most things.
Because there are buyers who are very keen to buy a property. So if you see the property and even you've got loads of information missing, someone may be still very keen to buy that property. Is the indemnity policy a way to protect the buyer, or is it
all it protects are claims by other people. People who could benefit from those claims, by the way. So if you had a freeholder who went missing, you can get an indemnity missing landlord policy.
So that's, you don't want to pay for years of unpaid ground rent, right? So you can buy the indemnity policy.
Yeah.
So we can as well use the indemnity policy for
lack of building regulations.
Okay.
Lack of planning permission.
So if you
environmental
buy
issues.
So if you buy a property with an extension and you're still very keen to buy that property, but there is no building regs in place.
Yeah.
Me as a buyer, I can just get an indemnity policy, and that just resolves the problem, or is there?
It only resolves the problem as far as the local authority is concerned, building control or planning.
So if someone knocks my door and say there's no building regulations, I can show them the indemnity policy,
and the insurance company will deal with it.
Fine.
But it doesn't cover the structure or how it was built. So
if it falls apart, the insurance policy will not put it right.
No.
Okay.
It only protects those things. Your search might throw something up, like a fence or surtax for windows, replacement windows.
Yeah, because this is an interesting one.
Yeah, building
the windows.
Yeah, very much so. Again,
for instance, our community will often order windows from Poland.
Yeah,
they will come to UK and they will just install them. There will be no...
Don't sell the property for a year, because after 12 months you can get an indemnity policy.
So okay, so this is a rule, right? So you have to have the windows installed for 12 months. After that, you can apply for the indemnity policy. What if you inform the local authority? Is that...
You cannot insure.
You can, okay, so...
You actually block your own copybook.
Okay.
You've actually killed it.
Because you've informed them about it, they are aware of it now, and...
Notification is, you must... In fact, the terms of the policy says you must not notify the third party.
Fine. And again, if I buy a property where a person have installed the windows and they just got an indemnity policy, this means that I'm not 100% sure whether those windows have been installed properly, but I'm covered by...
It doesn't guarantee the installation, doesn't guarantee the quality, but it stops the local authority from saying it's in breach of building regs.
This is nice clarification, because I think there are a lot of misconception around. So there's always a way out of the problem, but you have to know the consequences.
There's the, when you hit a brick wall, you can go over it, under it, round it, or you just go through it. Indemnity policies normally go through it. But
okay, just...
Yeah. Replacement windows in leasehold flats is another aspect. Did you get consent of the landlord? No. That will be a different policy. It'll be breach of restrictive covenant or defective lease policy.
So in that situation, the indemnity policy is really important.
Protecting you against the landlord.
Because then the management company can actually...
Enforceability of the leases. Yeah. It's a different policy again, but it covers windows.
Covers the windows. Brilliant.
So you need building regs, lack of. Landlord's consent, lack of.
And all the rest.
Yeah.
So as a buyer, what can I do to help the solicitor with the timescales to make the transaction nice and smooth? Is there anything the buyer can do from the get-go to actually help the process going quicker?
Divulge everything you need to tell us. Return forms properly completed and signed. Pay money when you need to pay it.
So for the searches, so just get the money right.
If we ask for money, it's because we need it. It's not because you just want your money.
So instructing the solicitor means sending all the paperwork.
Returning all the paperwork.
ID.
Telling the agents that we're instructed.
Okay, so you get the memorandum of the sale.
Getting your mortgage underway.
Paying the search fee.
Paying the search fees. But from the purchase point of view, I think without a doubt the mortgage issue is important. If you're going to get a mortgage, make sure you're doing it properly through the right people.
So to get the initial agreements and make sure that you can actually get a mortgage in place. So this is
Otherwise
something which we emphasise on.
Yeah, this is where you come into the fore of it.
That's right.
Because if they can't get a mortgage, they're wasting our time and wasting their own money.
So Ken, we talked about the internal aspect of the property and how that can differ from what we've seen originally. But how about the structure of the property? What happens when you buy a property and it actually has some structural problems which we're not aware of?
We'll wind it back because at the very beginning of the transaction, we always recommend to purchasers surveys. Because there's a law in this country called buyer beware, caveat emptor.
Okay.
You buy what you see. So it's very important you have a structural, if you will notice straight away if there's a problem with it. Cracks, structural survey. Don't mess about with it, just do a structural survey.
Because I know that the lenders are not always fussed about that, are
they?
No,
the lenders invariably drive past and say that's okay and rely upon what they see on Zoopla or whatever.
So drive-by valuations or even index valuation are more common because they rely on the tech, which doesn't give you that.
The reason they don't give much on surveys is because there's too much comeback against them. They miss something, but they just do valuations. They don't do surveys. It's a valuation.
So the mortgage, for mortgage purposes, just assess the value of the property.
Yeah. Although some mortgagees have surveyors, surveyors, who will say, "Oh, I notice so-and-so, check it," don't they? Okay. Yeah.
They do, do. That's right.
Yeah.
So the best thing is if you are worried to get
because if you go in and there are problems, again, you've bought what you've seen. It's like buying a second-hand car from you, Adam. Would I? No, not without a survey.
So you would have an AA check or equivalent of it?
Same as, exactly. Do that with your house. The house is a bigger investment.
So if a buyer phones you up after a few months and they say, "Oh, there is a tile missing, my roof is leaking, or there is a crack," so there is effectively you should have done something before you've actually purchased this.
If you've had a structural survey done and something crops up that the surveyor's missed, you've got to write a claim against his insurance company, his professional negligence.
So he will have a indemnity insurance.
Yeah, professional negligence thing, like all of us have to have.
Fine.
So surveys are very important.
Survey is the important one. Fine. There's a new thing which we see more and more these days, and they apply to the new build sites, but not only. But this is about the ground rent provisions. What can you say us about all those ground rent provisions and how expensive they can become one day, and why some lenders are actually worried about
the regulations on rising ground rents, which are normally on the probably 80s, 90s leases, doubling ground rents. Once they hit £250, outside London this is, by the way, you have got a problem. And unless it's index linked or has a cap so it doesn't breach the Rent Act, then you can't technically buy it.
So would solicitor advise someone, look, this ground rent provision is actually disadvantaged and you shouldn't buy it?
It's unacceptable to mortgagees, but it's also unacceptable to a buyer, because if you come to sell it, it's still a problem. So even if you didn't have a mortgage, it's still a problem. But there is legislation afoot, and has been for a little while in this country, to stop all that aspect of it.
Because it's very common now with the new builds, we see that, and people are actually not aware of that, because the estate agents wouldn't know about it again, would they?
No, they wouldn't. Mortgagees need to make their minds up. Some will say 10 years, some will say 25 years, some will say no doubling ground rents. So you have to have what's called deeds of variation. Long drawn out, very expensive hobby again.
So the deed of variation would be a change within the lease relating to this provision, is that right?
Yeah, and it shows you it's happening, because you say to the freeholder solicitor, the freeholder solicitor or the managing agent solicitor, it's not acceptable, and they send, where's the deed of variation for it? It's already set out. Okay. So they've had loads of them. How
much it could cost to actually start the deed of variation process?
Depends who it is. £300, £400, £500.
So it's an expensive process.
It's not cheap. Well, unfortunately, no solicitor's time is cheap. Not today.
Ken, I think we've uncovered a lot of questions, and it's obviously a very wild subject, and we could probably talk about other various things for hours and hours today. But I think we've answered some of the most common questions we're getting from our audience, from our clients. Yeah. So thank you very much for that.
Can I just add something? With buyers, if it's their first trip on the road to having a property, make sure you know what you're doing. Get proper advice. Make sure you've got enough money and can afford it. And if you look at a property and you have that gut feeling that there's something wrong, walk away, because you regret it. And it happens. And I'm a great person who believes it. If there's something not right, just walk away from it.
Would you advise someone to walk away as well when you see something?
We've done it. We've done it before. If they're desperate to buy a house, well, that's their decision. But you will know if the property's if there's something wrong. It's a massive investment for youngsters today to buy their first home. Don't panic, do it properly, and they'll get there and they'll have
rely on advice.
Yeah, and they'll have a great time.
This is amazing. So Ken, thank you very much for that.
Pleasure.
What we'll do, we'll obviously listen to all the comments, all the questions. We can sit down with Ken. I'm pretty sure he will agree for another meeting. I know you work very closely with Aga. She's from Poland. Is she your assistant, or is what's the relationship?
I call her my office wife.
Okay.
My inspiration of being here still instead of retiring, and I work for her.
Okay, that's interesting.
I'm her assistant. She is amazing.
I know. I'm obviously.
But I know you're recording this because I don't want her coming back saying more money, please. But she is very knowledgeable. And of course,
so if people would like to get some help and advice from yourself, who should they contact? Should they contact the office?
I would. We've always had a situation here where we would speak to people even if we're not acting for them, as long as they're not represented by someone else who would be in conflict with us. But we have an open door. Like if you said, look, we deal with you, but you're not involved in this. What's the scenario? We do that with estate agents. Can you help us? What should we be doing? Because the solicitors are not telling us. We will tell them.
So what I will do, we will obviously put the links to your website, all the contact details down below. There's going to be details as well for Aga.
I think with Polish clients, it's got to be Aga
absolutely.
And me if I can help her.
She's been a massive help for our clients. So we'll put all the details below, and if you've got any questions about the subjects which we maybe didn't touch on or we didn't explore fully, please make sure to leave the comments below or send us an email. All the contact details will be below this video. So please do not hesitate to contact us if there are any questions. I'm pretty sure there's going to be plenty more to cover. But Ken, thank you very much for your time today. It's been a pleasure. And hopefully we're going to have more of those coming in the future. Thank you very much.